Employee tips from an employment lawyer. Stop using company email. In this employee tip, we will look at the importance of discontinuing the use of company email for anything of a personal nature, with the concept of personal nature being sufficiently extensive so as to include anything not specifically related to carrying out your job function for your employer. This means that communications related to your employment, including human resources, employment contracts, payroll, performance reviews, bonuses, benefits, etc., should not be done with the company email. And if those communications persist in coming through company email, or they are contained on an external system, they should be retransmitted to your personal records and in your personal non-corporate email account. Furthermore, you need to be making a concerted effort to get away from the company email, unless it is strictly related to the business function that you are performing for your employer. This is exceedingly important given how employers view their ability to scrutinize and peruse company emails from their employees, using sophisticated computer tools to search for words and phrases that they might use to serve their corporate self-interest. Because this is all done out of sight and out of knowledge of the impacted employee, how and when this information is used and how it is interpreted is entirely outside the control of the employee. And one need only look at the invasive level of company email scrutiny that took place at RBC Royal Bank of Canada when they scoured the emails of their Chief Financial Officer and their Vice President of Treasury. As described in Toronto Life, quietly, without alerting the bank executives, RBC engaged outside legal counsel from a top-tier Canadian law firm and a team of investigators who launched a covert analysis of the bank executives' communications. By law, the company had the right to pore over a treasure trove of correspondence dating back a decade. It could even read communications transmitted over personal devices in cases where the bank executives had copied their work accounts. The degree of intrusion that the bank felt that it was capable of effectuating was considerable, with the full scope of its access being something we will never know and can only speculate about, given the incentive that the bank had to find anything it could use against its employees. Meanwhile, the employees, which in this case were extremely wealthy employees, had very limited recourse outside of commencing legal proceedings against their former employer, where the Chief Financial Officer contending that the case against her, she said, had been distorted, the evidence cherry-picked, the real story was nuanced and exonerating, and it needed to be heard. As for the specific accusations about her and her co-workers' relationship, she would later provide an itemized set of explanations. The messages that suggested romance were nothing of the sort. They were friends, full stop. Anything else was a fabrication. Nevertheless, the employer is capable of reading into the email messages what it wants, and it tends to have the financial resources to advance that position, with this being a whole other discussion about employer power and employees' apparent lack of power. For as Toronto Life put it, RBC has surreptitiously reviewed more than a decade's worth of its senior staff's correspondence. Neck-craning Bay Streeters were reminded they too had signed the same or similar contracts. Yet, as is evident from the salacious example of employers reviewing company emails of their employees, doing anything but the explicit business of the employer needs to be stopped immediately, with everything that is not specifically for your employer's business being done with your personal email. I realize that it might be easier said than done. However, if you want to protect your career and your reputation, among other things, You need to stop using company email for anything but explicit employer business. This is not to suggest that you would be doing anything nefarious or improper from a practical standpoint. Your personal email needs to take precedence, and your company email should be limited for a whole slew of reasons, not the least of which is your employer forwarding your employment-related emails, as opposed to business-related emails that are actually meant for your personal retention. Yet by sending them to the company email address are all too often inaccessible once an employee is terminated. Together with losing access to other personal data and messages when your access to your company email is revoked upon termination, it is important that you discontinue the all too common over-reliance on company emails for anything beyond employer business. Your top priority should be on yourself, such that you need to stop using company emails outside of your employer business work. And should your employment be terminated or you otherwise leave your job, you should consult with a lawyer about protecting your interests, even if you aren't aware of anything that demands protection, as that is for the lawyer to explain to you. For knowledgeable legal counsel with respect to the end of one's employment, contact our law firm for experienced legal advice for employees. Thank you.